Good afternoon, and welcome to the Quarles and Brady Business Law Training Session titled Crisis Communications, Finding Out What Happened and Controlling Your Message in the Face of Intense Media Scrutiny. I'm Kim Mahan, a partner here in Chicago. Before we begin today's presentation, we would like to invite you to join us on November 7th for next month's program on the California Consumer Protection Act update. As always, we have a few housekeeping items to review. For CLE credit, for our in-person guests, please fill out the CLE sign-in sheet located at the registration table before you leave today. For our webinar guests, please email the CLE form located at the back of the PDF materials to Sarah Rebessa, whose contact information is on the form. You can find today's PDF web materials under Handouts in the Go To Webinar pop-up box on your screen. If you are listening via webinar and have a question, please type your question into the question box on the upper right side of the screen and press send. The conference host will make sure the speaker receives the message. Also, for our webinar participants, we have muted all phone lines and participants are in a listen-only mode. A survey will be emailed to you after the program. Please be aware that this presentation is being recorded. And now I'd like to introduce today's speakers. John Hackbarth is the National Chair of the firm's Securities Litigation Team and the Milwaukee Office Chair of the firm's Healthcare Litigation Team. John also works with clients across a variety of industries, including technology, healthcare, banking, and security sectors to enhance the quality of their legal services and decrease their overall legal spend. Having started his legal career working in the legal department of a multinational corporation, John understands how outside counsel can partner with clients to achieve their desired goals. Dan Conley is a trial lawyer who serves as a trusted advisor to corporations, executives, and lawyers on business disputes, litigation and transactions, and legal malpractice defense. His experience ranges from trial advocate to mediator, business advisor, crisis response consultant, and expert witness. Dan maintains a Band 1 evaluation from Chambers USA and served for many years as legal counsel to Quarles and Brady. He regularly advises clients on sensitive matters subject to significant media scrutiny. Jody Lowe is the President and Managing Director of the Lowe Group, Financial Communications. Jody is an experienced communications professional specializing in communication strategy, strategic communications, investor relations, media outreach, and media training. Prior to launching her group, Jody spent 16 years with Strong Financial Corporation, investment advisor to the Strong Funds, where she directed media relations and corporate communications. And now I'll turn it over to John.
Well, welcome everybody to Quarles and Brady, and thanks for attending our presentation today on crisis communications. As was mentioned, my name is John Hackbarth, and I'm a partner in the Milwaukee office and chair of the Securities Litigation Practice Group here at the firm. At the start of my career, we were involved in a high-profile case out east. And I'll never forget the morning I came into the office and I had a voicemail waiting for me from a reporter for the New York Times who wanted to talk to me about the case. I ran down to the partner's office who I was working with, and I proudly announced to him that a reporter from the New York Times wanted to talk to me about the case. And he looked up at me with a very unimpressed look and told me that I could tell that reporter to go jump in a lake, which is not the most effective media communication strategy. Ultimately, we gave no comment to the reporter, which was the appropriate response in that situation. But the partner's comment, although made in jest, really does highlight the need for high-profile matters to not only have a legal strategy in place, but also a communication strategy. And lawyers are generally pretty good at formulating a legal strategy, but oftentimes overlook or entirely disregard the communication strategy, which can be as important, if not more important, than the legal strategy. So it's critical to involve somebody either internally at your organizations or externally who has expertise both crafting and executing a communication strategy. And just very briefly, we covered some of the background of our guests here today, but wanted to introduce you to Jody Lowe. And it was mentioned she's the president of the Lowe Group, which specializes in the financial services industry, supporting asset managers, wealth management and advisory firms, and other financial service providers. Her firm helps clients with media relations, crisis communications, content development, and other marketing and communication support. In addition, on a personal note, we have retained Jody and her firm, and I cannot speak more highly of Jody's ability to come in and craft and execute a media communication strategy. Dan Conley is a senior partner in our litigation group here in Milwaukee. And as it relates to crisis communications, Dan has led teams that successfully challenged as unconstitutional under the Commerce Clause, a Missouri law designed to hurt the competitors of an international corporation based in Missouri. He successfully challenged the federal government's attacks on a Milwaukee school's interest in the proceeds of a Milwaukee casino. He served as the lead negotiator in the sale of the Milwaukee Bucks and Senator Cole's successful effort to keep the Bucks in Milwaukee for another generation. So next time you attend a Bucks game, thank Dan for keeping the franchise in town.
Senator Cole.
Yes, they could have very easily gone elsewhere. And beyond that, Dan has advised many clients on high-profile matters that haven't become public, and Dan assures me won't today. So to start, Dan, I'd like to turn it to you, and if you could take us through your crisis communications checklist.
Sure, thanks, John. So you should have, and those listening just by the audio, should have as well as a separate PDF, a two-part crisis communication sheet, which is in the materials as well. And the people watching in the various offices have a copy of it in front of them. I'm going to come back to that. That is a tool that I've created and used in various forms over the past 20 years. On day one, hour one, conversations with in-house counsel and executives on the types of issues that you face. And it's meant to be a cheat sheet. So right at the beginning, you can think about what it is you're facing and what your choices are going to be. It's also set up as a kind of a balance between your typical public relations response to a high-profile matter and the typical legal lawyer response, which tends to lean towards not participating, not engaging on the press. I do want to follow on what John said about the New York Times call in 2 points. One, I'm pretty sure that the most dangerous thing I ever did as a Quarles and Brady lawyer is stand between that same lawyer that he talked to, stand between him and the press. So he wasn't shy in other contexts. And secondly, I also represented a law firm, not ours, where an associate had the bad sense to have an extended conversation with the Times, quote, off the record, and that's how the story appeared. But it became obvious later in the litigation who the source for that information had to have been. And it badly hurt the client, it badly hurt the law firm, and it goes to something Jody will talk about later in terms of really understanding the rules of the press and how things work. And the Times never outed the person, despite attempts to out him, but it was pretty clear who it was in any event. So briefly at a high level, we talk about crisis management on occasion. You don't manage a crisis, you respond to a crisis. Think maybe of a wave and hopefully you don't get knocked off the surfboard and into the sand. But you can try and respond in ways that are more meaningful. The real problem in crisis management as it relates to businesses is when a crisis occurs, which I define as something that will or could get intense media scrutiny or great interest in the public, and some serious underlying event, whether it's legal, it could be a literal explosion, a financial explosion, or otherwise. And the company needs to react quickly. And the hardest problems are those where top management is dealing with, for the first time, with an internal investigation, with significant litigation, and with the media, with little experience in any of those three. That's the worst situation to be in. The companies that react best are those that have good hygiene in all those areas generally, have some sense of what attorney-client privilege is, its limits, have some sense of a communication strategy generally, and has some sense of what an internal investigation is. Most people end up in a crisis don't have any of those things. And we've got a very broad audience on the phone today, governmental entities, not-for-profits, Fortune 50 companies, and everyone brings different resources to these types of issues. And the real question from the legal perspective is how much legal involvement you need and when, and is the game worth the candle? And sometimes it's obvious. If you could look at the New York Times front page today, and those of you not seeing us by video, the headline is Boeing Rejected Safety System for 737 MAX Jet Engineer Says. Now, when the first plane went down, Boeing, I'm sure, launched a huge investigation using the benefit of the attorney-client privilege, work product, and everything else to find out what was going to happen because they knew what was coming. Months have passed. This complaint apparently got filed after the second crash. But this is one on day one, the lawyers and the in-house people at Boeing, when that first plane went down, knew that they had a real situation on their hands, devoted a lot of time and attention to it. For your typical small business, and some are on the phone as well, with a single lawyer in-house department, with some more minor thing, obviously you're not going to respond to a problem the same way that Boeing did. And one of the things you need to figure out in the short term is how much you want to invest. And it's not just lawyer time, but it might also be outside consultant time. And my goal in every situation I've been in like this is to limit the lawyer time as soon as possible. And sometimes I tell them, you don't need a lawyer, you need a public relations consultant, and give me a call if anybody begins to get nervous about what the legal issues may be here. Other times it's just a lawyer, and sometimes it is both. So that's the real hard thing you need to figure out right up front. The cheat sheet, meanwhile, goes to both the finding the facts and the communicating the facts. And you're going to hear about triangles later, communication triangles from Jody. I focus on circles, and in particular on who needs to know what. And as I'm gathering the information and I'm working with the client, is this something that we need to get to the board? Do we need a special committee? Is this just for the top executives? And as I learn particularly sensitive facts, which I rarely put in writing, with whom do we share them? And when we get to the list of people on the cheat sheet, you'll see there are a lot of different audiences that you can be reaching out to. One of the most delicate things, I've worked with a lot of sophisticated inside and outside public relations firms over the years. One of the most delicate things is when you get a piece of information that if it becomes public, you're going to want a public relations strategy. But you also recognize that many judges don't believe that there is any role in the attorney-client privilege for a public relations consultant. And they ask, okay, tell me how the public relations consultant was necessary to provide legal advice. So you need to figure out how far down the road you're going to go in terms of sharing information with on the PR side, inside or outside, because there's always the risk that what you share might subject to the Jodys of the world to discovery later. And that the things that you thought were secret may not be secret. Now, again, in this balancing that you're doing from the very first day, at some point you might think the brand is more important than whatever this legal issue here is. The attorney-client privilege, even if we lose it, is less important. So we're going to go all in on the public relations consultant, and everything we know, they're going to know. You can also finesse it. You can say to the consultant, Jody, as you know, we're dealing with whatever this difficult issue is. There's a possibility sometimes in the future an allegation may arise that, and she can start thinking about it. So if that allegation does arise later, she's in a position to talk about it, but I've been coy up to a point in terms of the attorney-client privilege. I'm not concerned that a judge who has a narrow view will think it's waived. Two more brief points before we go on to the cheat sheet. The first is that the attorney-client privilege needs to be in the context of an attorney giving legal advice or getting information for legal advice. Lots of companies, lots of clients have no idea how it actually works, and they think that any dumb idea they put on a piece of paper, and if it ends up or is CC'd to a lawyer, that's privilege. That's not how it works. Secondly, in-house lawyers are also subject and can create an attorney-client privilege Judges are much more skeptical of an in-house privilege for lots of good reasons. If it's worth it, it makes sense to hire an outside law firm. You're much more likely to have the privilege. The same is true with in-house PR people. An in-house PR person, a judge is more likely to think, yes, this is a top executive. They're in the meeting. They're meeting with the lawyers. When you go to an outside PR person, you often, frankly, are going to get more talent. But you also need to balance the risk in terms of just how much you shared with them that the privilege may be hurt there.
Can I ask a question?
Sure.
About that, Dan? I mean, if so, in securities litigation and things like that, when you're communicating, we've often made sure that we copy lawyers just because it's important for the lawyers to review it, because what we need to say needs to be consistent with any settlement or the legal rules, right? So there is a reason why a lawyer needs to be involved with that. And does that help to maintain privilege in front of a judge?
So what you're doing is unlikely to be privileged generally in what you're sending to us, and I like to limit that sort of stuff in writing coming from you to us. What I'm doing, which is the reverse, I prefer to talk to my PR people as opposed to send them emails and create a paper record of what's going on. And the related issue is I dealt with something very difficult recently that will hopefully never become public. In reaching out to another party who's part of it, I called their lawyer. So it's a lawyer talking to a lawyer, which is the least likely thing ever to be subject to discovery. Nothing is in writing. And lawyers talking to lawyers are also much more careful about what we say and how we say it. And you can communicate the information there. But the point you're making about consistency of message is the most important thing. And I began my career as a younger lawyer, and even though I'm a news junkie, skeptical for ethical and other reasons of meaningful PR participation in high-profile litigation, let alone crisis management. And I think that's just foolish. And where you really end up is on things that are really going to get that attention, the message you want in court ultimately is going to likely be the same message you have outside as well. So you very much need to coordinate with your PR people. And PR people are better at communicating often than lawyers, both in court and out, because you think about it differently as well. So I'm just going to touch briefly on the sheet, John, and then I'll go back to you. So literally the first 5-minute conversation that I have with lawyers and executives I can give for you right now. Here's this cheat sheet. We need to identify and gather the key decision makers and confirm and assign responsibilities, who's doing what. In modern corporate America, often the key decision makers are in a different city. They're on a plane, they're commuting, they are unavailable. I hope you have a backup, because 3 or 4 hours is a lifetime. In a major manufacturing explosion I worked on, where 3 people were killed and 100 badly injured, and the factory was out for 2 months, we had our first press conference 3 hours after the explosion occurred with the mayor and with the chief of police. So when you're really in it, you have no time whatsoever. And if you first need to figure out, okay, who's available to participate in these decisions. Consider bringing in outside expertise or depth. A lot of different reasons to do it, and it can be expensive, but it's issue spotting. Objectivity can be helpful in circumstances like this. Again, you need to be focusing on the work product, the attorney-client privilege implications of communicating with these people. First things first in a crisis, lots of PR and lawyers stand up and will tell you how swell they are, and we're very swell. I don't mean to say we're not, but these are fundamentally business problems needing business solutions, and those are the real challenges in most of these instances. And we are there to provide professional counsel and help them, but these are really business problems in the end. 4, and where the lawyer plays a bigger role and why it's worth the expense of getting lawyers involved if the game is worth the candle, we have the ability to gather information and keep it secret as a matter of work product and privilege. Now, we can't change the facts, but I've been through enough of these that I know that people often make big mistakes in what they put in writing right up front because they don't know. And 2 years later, when you're in trial, you need to defend these things that were said that were not helpful and were wrong. So you can't underestimate the importance of gathering this information by professionals in a way that you control what's secret and what is not, certainly in the short term. Focusing on the key audiences, I'll come back to this, but as I said, I think of circles. So it's me and the CEO and the general counsel. That's the smallest circle. Then maybe the special committee of the board, then maybe the board later, maybe it's our key customers. I've worked with lots of not-for-profits. I was thinking about it, probably more than 20 over the years in circumstances like these. And the not-for-profit board members don't get enough credit for what they do every day, but they especially don't get enough credit for what they do when there is a crisis. They are not being paid. And the test that the question I might be asking myself would be, if I were in their shoes, is this a good day to resign from this board? And instead they engage and they're very much involved, but there are lots of constituencies. So the number 5, focus on key audience relationships and coordinate appropriate messages and responses to each, is just a checklist to think about, okay, who do I need to call? If it's a death case, I need to call OSHA within 24 hours. Although in the higher profile matters, OSHA is on your site in about 20 minutes, so you don't need to worry about calling them, but you're supposed to.
Dan, can I chime in on that?
Sure.
Because I think, you're talking about the circles. The key message from a communications perspective is you don't have to communicate with everybody in every circle. And I think there's a tendency sometimes on some people who are good communicators that, okay, what am I going to say to this one group of people? And sometimes it's better not to say things, right? But what we often do, and we agree with this completely, is we'll create what we call a communications matrix. You identify all the different constituencies and you rank them, right? Your board needs to know right away. The CEO clearly is in the loop, but what about your shareholders, your partners, right? They're going to need to know before other employees in the group and managers. They need to be ranked, right? So, creating a matrix and putting a timeline together on who receives what information when is a critical organizational tool.
Yeah, and it's no question. It's one of the hardest decisions. And depending about, let's say, day 1 or 2, I think we've figured out who the most important audiences are. We probably figured out, are we likely to be a plaintiff, a defendant? Are there criminal implications? Are individuals in the line of fire? Are we likely to be none of these things or all of these things? And all that affects what our communication strategy is going to be. And you start doing that balancing, and that's bullet point 7, the litigation, PR objectives and concerns. What is more important? You may just have to take your medicine in court, and you need to make your decisions to run the business and just go ahead. And lawyers cannot get in the way and slow things down, say, don't do this, oh, we need more time or anything like that. You pays your money, you takes your chances, which is a significant piece. And then you need to figure out who should be speaking on behalf of the company. And on many occasions, the answer is the CEO. The CEO has never had media training before, and they get media training in the hour right before they go talk to the media for the very first time, which obviously is some important lessons for you here. So that's the type of thing that you're balancing, and I will just make one point up front and at the end, which is I've done this a long time, and I like the spotlight as much as anybody. You should be very careful of lawyers who want to be the center of media attention, and you should be very careful of public relations people who want to give you legal advice. And those are some of the most interesting conversations I've had over the years directly with very talented outside and inside PR people about what we should be doing.
Dan and I talked about this before. A lot of the situations that we deal with are not, where 3 people die in a major catastrophe. It is literally a SEC investigation, and you want to think about who should be out there. And in those cases, I don't think it should be the CEO that's out there speaking. So there's times when those CEOs feel really strongly that they want to be the spokesperson, but they've got reputation risk and the company's reputation risk that should be considered. And so, often we'll try to get the general counsel to be the person who is the spokesperson in a regulatory matter.
And from a legal perspective, anytime you have somebody speaking, you may have created a witness that you might not wanted to have created. So we look at that from perspective. On the other hand, if the company's messed up, it's really good if the face of the company, the CEO, is giving the apology, saying whatever it is that needs to be said. And at some point, Jody,
right.
I think you agree. On the other hand, if you're a major audience and you rank your audiences, you could say, who are we most afraid of? I'm pretty afraid of the SEC, generally speaking. So
yes.
I may compromise my communication strategy with one group, lest I put myself in deeper trouble with the one I most care about. And we lawyers, we're mostly focused on the regulators and the courts. And we don't want to do anything that puts us in too deep a hole there unless other brand considerations are more important. Mm-hmm. And then it's the client's decision.
Right, for sure.
And Jody, you raised a good point. Sometimes a crisis comes out of the blue. For example, it's hard to prepare for a factory explosion. But other times you see it coming and you get to prepare. Can you give me some examples of instances where you can prepare
Yep.
for these types of events and you can see it coming?
You know, most of the situations that we're dealing with are not crises in the sense of, you know, you've got people standing on your door, you're a government agency, and you have to release information right away because there's a significant investigation. And most businesses, I think, more often are dealing with the kind of day-to-day crisis that are not going to bring your company down, but they're going to cause short-term reputational damage. And your goal there is to try to reduce the sales impact. You know, you could see a reduction in business. You want to try to reduce the reputational damage, and you want to try to get through this negative crisis and get to the next level. And it may not necessarily be a crisis. Many of the things that people are dealing with are mergers and acquisitions, things that are the natural part of business. You need to spin off a division of your company, and you know it's going to be hard news to take, and people are going to be affected. You want to be very careful about how you communicate about it, but it's not necessarily going to cause long-term reputational damage. So, you know, we've listed a couple here. There's regulatory settlements, there's lawsuits in the Me Too era. They've been a little bit more public and newsworthy, and unfortunately, if you face a lawsuit on a topic that's very much in the news like Me Too, you better be prepared and think very carefully about how you communicate about it. Key executive departures. We had a CEO of a company who ran for Senate, and you know we had to very quickly communicate about what was going to happen with the company. Good news was that he had done a fair amount of succession planning. It was a very positive story, and it was easy to tell. But on the back end, when he didn't win a Senate seat, you know how that was communicated about was a little bit of a muff on the part of the company, and they ended up having some ongoing trouble. So you need to think very carefully long-term about those kinds of communications. And then, you know, again, technology is a topic that we all need to be paying even more attention to. It's not on this list, but data breaches, privacy issues, you know, the Facebook, Cambridge Analytica, and, you know, Equifax, Target data breaches. Those are the things that become part of the news on a daily basis. And so you need to take those kinds of situations very carefully.
And I would say on the legal front, that is by far the most frequent and burgeoning area, which is companies getting hacked and getting their operations shut down. We're reading about it. County governments are easy targets. Law firms have been shut down. And there is an honor among thieves aspect to it, which is that they will give you control of your computers again after you pay them. I had dinner with a friend who runs a small business, $230,000. Now, that's typically a case where hopefully you've thought about this in advance. You have cybersecurity insurance, and we generally don't do it, but there are panel counsel who come with the insurance policy that will help you respond to those sorts of things. They're very good at it, and they will, if depending on what your insurance is, you'll get control of your computers again. Another great scam going right now is they get within your email system, and they have the CEO send the CEO who is in France on a long planned vacation they knew about because they looked at his calendar, and he sends an email to the CFO and says, oh, by the way, we're moving that closing up a week. Please wire the $4 million to that account early. And the CFO, of course, does everything that the CEO says, and so he does it. There are lots of different ways where companies are trying to figure out how to respond to that and similar issues. So at the end of the program, and right now I'll say it, you should do a risk audit. You should figure out what it is that your particular business should be worried about, thinking about different ways that you could be affected by it, and think about what your communications plan and crisis response plan will be.
And Dan, do you normally recommend that people have on the shelf sort of like a crisis plan? I mean, like, you know, the guy who's on the airplane and you've got a significant crisis and a news conference in 3 hours, you need to be able to reach those people, and you need to have sort of your key people ready. Generally, are your clients putting kind of a crisis plan or a risk on their shelf?
So I'm recommending it depends on them, and often they're too big and too long, but they should sit down and do kind of a tabletop discussion about, and it depends on the size of the company. Yeah. One of the most important first calls is insurance. Mm-hmm. And maybe you're calling your broker, whoever it is. People need to know who it is that they're going to call. Maybe it's the outside lawyer. Maybe it's an outside PR person. Yeah. It's who's number two if number one isn't here. One of the real problems is CEOs who are very hands-on and decide everything. They sometimes don't. You cannot have the time. You don't have the the ability to have them deeply involved in every decision that's being made in a crisis. So there are lots of moving parts. But yes, you should have a plan who's going to be involved, if nothing else, and who you call.
Right. Good. Do you want to move on to the next one? Should I go through a couple?
Jody, if you could cover
Sure.
some of the consequences of failing to prepare for these types of foreseeable events.
Right. And I think I'm going to talk through this a little bit now in terms of how you prepare some of the challenges. And Dan touched on this: incomplete information, reputation risk for key employees. That if your executive or a key executive is named in a lawsuit that's going to be out there, that can be hard for you in terms of new business development. In our industry, people who have securities settlements end up being sort of put in the penalty box. This has to go on their ADV form. So those ultimate settlement and how you communicate about it can come up again and again in the future. I think one of the biggest challenges companies face if they don't communicate effectively about this is losing key personnel. Your company, may be thinking about merging with another company. Some of the rumors are out there. You haven't thought carefully about communicating. You're creating that communication matrix. Those key person risk is critical at that point. How are you going to get to those people and lock them in and make sure they're still part of your organization? Because if they lose, it could be a big hole in your financials.
And people you're recruiting too.
Yeah, recruiting too, or new business. I put this on the list too. You're about to close a big new deal, and news breaks, and it's in the how are you going to close that new client if they see this negative news out there? It's likely to be put on hold. And the other thing I think a big consequence is if you don't handle things right, and you want stories to go away quickly, is other regulatory bodies start to take a look. The New York Attorney General makes your company the poster child. Wisconsin's Attorney General, the SEC, DOL are calling you the next day. So again, I don't need to use Wells Fargo. Everybody knows about Wells Fargo, and I apologize to any Wells Fargo people in the audience, but you all are painfully aware that news about their fraud with credit cards broke in 2013. It became widespread in 2016. And even this year, their staff is down 8.3%. They've got a cap on the assets based on a regulatory matter. And that whole story continues to linger. So, do we want to talk about process now?
Take us through the process of how you and your clients really prepare and execute a communication strategy.
Dan has got this really terrific form. I would hold on to that form because I think it lays out many of the same things I'm already saying. But one of the first things we always do is try to gather information. And again, hiring experts to help you gather that information is good, but most of our clients are small companies or smaller organizations, and they're going out and they're trying to put together as much information as they can get. When it's a regulatory situation like an SEC settlement, there are other people who've been through this, and you can take a look at, what is the SEC likely to do? What are other consequences? What kind of news has happened on these? You can get as much information as you can. The other thing that I want to mention and be prepared for, and again, when you take calls from reporters, this may come out, but there's other negative news that can often come out when your company is in the midst of a situation like this. If you're going through a corporate spinoff and there's some other skeletons in the closet, you may find that other news breaks about your company, and you need to be fully prepared for anything else that might come up as a result of your company going into the headlines. We talked about creating a communications team, and that team is really critical. Again, it starts out generally with the CEO and the legal counsel. At some point, your communications person is brought into the loop. You might want to get a technical expert, especially with a data breach, somebody who can help you, fully understand it. We generally think teams should be small because they need to be quick and nimble, and the wider you expand that group, the more likelihood you have of a leak. And, generally, if you're dealing with a crisis, it's already out there in the news. But many of the times we're dealing with firms that are trying to keep news from breaking and getting out there, or controlling the way that news gets released. So when you're planning for that and going through the process, you want to try to keep your team small so you can better control, how the team works.
And so you've got a small team. Tell me about how you control the other thousands of employees from posting on social media, sharing with their friends.
It is, depending on the situation, if it hasn't gone out widely within your employee group, you have to act pretty quickly because news does tend to spread, meetings get canceled, people put two and two together and they ultimately figure it out. and they start to ask questions. So you want to move quickly in any situation. When it does start to get out there, again, before it becomes public, we always talk about, maintaining confidentiality, naming the project with a code name, to do things so that it's not in the subject line of an email. And again, you want to try to avoid written communication, as Dan said, but there are things that people can do to make absolutely certain, and anybody who's in that circle needs again to be reminded to, keep things on phone calls instead of in writing. If you do have something that's in writing, keep it in a locked drawer. Don't leave it on your desk. Certainly don't leave it on the printer. And these things sound, like they're obvious, but people don't always, they need a reminder. Again, you don't want to inadvertently email something to the wrong person. So you want to be really super careful and make sure absolutely that who's ever part of that team is aware of those rules. And if you assign somebody to the team, you also need to make sure that they're realize that this is a priority. They may have other things that they need to do, but as Dan says, things move very quickly. So somebody else has to take care of their other responsibilities, and they need to make sure that happens.
Let me just emphasize that. So people show up for work. They're very busy with all the other things they're supposed to do. And now they're consumed for the next 2 weeks doing something they hadn't planned to do. It's very hard.
It is really hard. And again, sort of, as the leader of that team, generally the CEO, the general counsel, you need to sort of be thinking through that as well. And, maybe it's the communications person, but if somebody's on that team and they need to, they've got to get other staff dedicated to make sure that things get done, and they need to do it in a way that it doesn't necessarily spread the circle of people that know about it. Moving on to talking about the message, one of the first things this team needs to do is to sort of lay out what is it that we can say about this? And before you even think about reaching out to all those different constituencies we talked about in that matrix, is you want to create what we call a message triangle. And that's sort of in a nutshell, what's the situation and what are the 2 or 3 things that we can say about it? And that messaging, again, it takes a little bit of time to get it right. It has to accurately reflect the situation. It needs to be factually correct, but it doesn't necessarily need to be extensive. And in fact, the less is more in most cases. And very early on, even before we're crafting communications materials to go to clients or the community or anybody else that needs to know about it, we're sure that the legal counsel is involved in reviewing that messaging. And again, how we deliver that may have to be delivered over a secure portal of some sort, or we may even deliver it in writing in person, so it doesn't get communicated via email. But we do work really closely with attorneys and feel, again, I think in most instances the lawyer is on your side, because you don't want to say anything that's going to undermine the company's legal chances in the future. But again, you're working together to make sure what gets said is accurately reflecting the situation. And then you sort of try to customize those messaging for various audiences once the time comes and you're needing to craft what communication is going to go where and when. Identifying spokespeople is important, and Dan really touched on this. There are people that are really good talking to the media. There's also really, people who are very good talkers. The critical skill, I think, for somebody who's going to be a spokesperson in a crisis situation is discipline, because what you want them to do is to deliver a short and concise message and stick to that message, and to be able to use tools to come back to that message, or to be able to say to the reporter or to any other audience, we can't address that topic right now. What we can say is this, and really keep coming back and repeating again and again the core message that you've agreed upon, and avoiding commenting or discussing things that you can't comment on. Again, we talked about when to use and not to use the CEO, but I think especially in security settlements, often the CEO is named and they feel badly about it, and they feel like, I made a mistake, this will never happen again. We've done everything we can to address the situation. They want to tell people personally. I think sometimes it makes sense for them to make some calls to some key people, but as far as being the spokesperson to the press, it doesn't always make sense. And then again, making sure that your people have received media training. It's great if they've received it before and they've had some experience. If they haven't, you certainly want to put them through practice for their particular interview at the time with somebody who can actually prepare them with tough questions that they might actually get at that moment, which I think is important. But again, there's a lot of people who are very good talking to the media. They aren't necessarily good in a situation like this. So, all right.
And will you sit in on the meetings with the press on occasion?
We will. And again, in most instances, we almost 90% of the time try to execute any kind of interaction with the media through email. When we've gotten to the point where we've announced news and we're getting it out there, especially with M&A situations or regulatory settlements, we are taking questions from reporters via email and we are responding via email. So we're 100% sure that what we're saying is consistent with what we've agreed with the lawyers that we can say. If there is an instance where we have to do a phone interview, and again, in a mergers and acquisition situation, sometimes there can be some benefit. Could be a very positive story and you want to do an interview. And in most cases like that, I will stay on the phone call because there may be something that was missed in the interview, or there may be something that came up in the interview that needs to be clarified later. So in a situation like that, you generally want to have somebody there who can take notes and follow up or clarify on the spot if something that was said that was probably outside the agreed upon messaging.
And one of the points of my outline is that you want to have somebody, depending what communications channel you're in, whether it's to a judge or to a reporter, who understands the rules of the game. And maybe you want to talk about on the record, off the record, or something like that. But just generally speaking, it's the same reason you would like to get a lawyer who knows the local judges, knows the rules, because they are not going to get you in trouble. If you have some high-profile matter, to have a public relations person who understands what the rules are, who this reporter is, who you can trust, who you can't trust, it makes a huge difference in the outcomes on the press coverage.
Well, the one thing I can tell you, and having worked with media for a lot of years, there isn't a reporter that you 100% can trust, because honest, their job is to tell a story and to ask the tough questions. They're just like attorneys, like an opposing attorney. And if they're doing their job right, they're going to ask you that tough question. That's their job. Your job is to stick to a message and to be able to not answer some of those tougher questions in a way that doesn't sound like you're guilty or no comment, right? It's a real skill to be able to do that. And very few people can do it. But, do you want me to talk a little bit about rules of off the record now? Because I think there's a couple different ways that people will use things like on background and off the record to try to control an interview with a reporter. On background, you're trying to educate the reporter with details about the matter, and the rules are that they can use the information, they just can't quote you. Now, in the instance that Dan mentioned, it's really pretty easy to figure out who the source of some information is in many instances. And even without, you being named, it can be very obvious to other people. So if you don't want to see something in print, don't say it. And that's my number one rule that everybody should take away, even on background. And I think people feel like I can try to manage the situation. I've got a relationship with the reporter. I can help them write the story. But if you don't want to see something written about and have it connected to your name, you shouldn't say it. Now, off the record rules I've been burned on in the past, and it's really easy to get burned on. And certainly Anthony Scaramucci was burned extensively on this, at least so he says. Off the record, you have to tell the reporter in advance of saying something that something's off the record. The reporter needs to note that in their notes. If the interview is being recorded, you need to ask them to turn the tape recorder off. And then that's agreed in advance. You can't say something and then say, oh, that was off the record. Because once it's said, if you haven't negotiated that in advance, you can. Now, and I've had situations with Wall Street Journal reporters where we've agreed that something was off the record, and it wasn't a crisis situation, but the analyst did not want to be quoted for one reason or another. When the analyst didn't tell the reporter that something was off the record, the reporter still used it. Now, I never worked with that reporter again after that happened because I felt like I had told them it was off the record, and to me it was sort of a subtle breach, but it goes to the point that I'm saying that the rules are very specific, and if you don't know the rules, you have to be really careful about it. And bottom line, anything you can say, the reporter can follow the rules of off the record. They can be reputable reporters, or they can say you never said it. And if they weren't in the room and I wasn't in the room with you, no one will know, right? So you have to be really careful with it. And if you don't want to see it show up in a court of law, it's probably not a good idea to say it off the record.
And Dan, is your
And I just want to reinforce the point. I would never say, or be involved in authorizing an outside PR person saying anything to the press that I couldn't live with if they breached their promise to me. It's just too much trouble. And it's one thing if it's completely on the PR side, but going back to who your various audiences are, judges really don't like lawyers talking to the press generally. And there are rules that limit your ability to say things, and to the extent it would poison the jury, et cetera. So you just need to be very careful about it. And I know lots of reporters, and I couldn't agree more. I don't trust them. Some are my friends. And the main thing to them, and well, the news hole is getting smaller and smaller. We should probably talk about that a little bit.
Yeah, for sure.
Is that their main goal is to get above the fold on the paper. Now, I guess, is it Sunday night? When do they want to release their stories online? There's a particular time they want to release them. Their main goal is to have their byline beneath some story and get all the press. And they are not there to make friends, and they are perfectly willing, in the interest of a good story, to push what even we think the rules are. The bigger problem, however, is clients who get a call have no idea what the rules are. And very similar, if you've ever been prepared for a deposition, litigators will tell you the other side wants to turn this into a conversation. Just have you start talking. Reporters love the same thing. They will play to your ego. They will imply that they're not going to tell anybody. And those are the people who really get chewed up by the press.
Or they'll put their notebook away and you think they're not taking notes anymore. I mean, you should always assume that any conversation is on the record until you're not in the same room with the person, right? It can continue to be on the record.
And then there's the flip side as well, just because it's fun. So leaks.
Yeah.
On the leaking side, the judge I worked for as a former governor, he used to always say whenever something appeared that was a leak, who benefits, which is a great way to look at what might have caused somebody to say something. It also helps you figure out and source it, et cetera. But the press, they will play dumb. They have lots of information before they even call you. And suddenly they've got you contradicting something that they've independently pinned down other ways for it. So it is not a sport, especially in high profile matters, for people to dabble in. And more with social media, lots of people are dabbling in. So the controlled situation you talked about, the other version is lots of press. I have a son who works for WeWorks. So he texted me some of the texts that his friend was sending him. And I said, call your friend and tell him that stuff like that is discoverable and you really don't want to be putting it in writing. So people are in the middle of something, they know a secret, they know something that's high profile, and they want to show how important they are. There are versions of it where they put it on Facebook. It goes to message control, and the people who work in your organization should understand that the only people who speak on behalf of the organization are people who are authorized to do so, and or the press people, especially with highly sensitive matters. And sometimes right after things go badly, you need to send that reminder to everybody so they know not to start creating news or worse yet, evidence.
Right, and have any calls like that be directed to somebody and make sure they know who that person is.
Dan, following up on that point, as you're crafting a communication strategy, what legal and ethical concerns should our guests keep in mind?
So I tend to approve more than craft it, and I try and stay out of the way of the good PR people for a lot of different reasons. Especially as you know, partners at law firms, there's nothing we like to do more than edit. So I'm not adding a lot of value when I'm editing at that. I'm looking only at substance. And my main concern is, what is a judge going to think about whatever it is that the company is going to say? What is the opponent? What is the other side? What are the regulators going to say? Am I creating evidence? Am I speaking when I don't have to? Mm-hmm. And you can accomplish an awful lot and not really say anything by using more vague statements, which communicates the message but does not pin you down. The real problem, especially with the crisis response, is you don't know what happened. And as you find out what happened, you can begin releasing more information and getting whatever your message is going to be. But it's a real problem for me months later, whether it's in court or years later in court or before regulators or otherwise, if we say something that wasn't true, that we in good faith believed to have been true at the time. So that's the real battle. The other big ethics issue in these sorts of things are, we represent typically the company. And sometimes there are individuals who are going to become adverse to the company because they did something really stupid for which the company is responsible, or they have their own criminal exposure, or you need to interview people who you're reporting to as the outside lawyer, and then you're going to turn and take whatever you gain, talk to other people at the company, and then you're going to send that public message out. One of the traps is, does the person I'm interviewing need their own lawyer? Now, I've never been of the view that I somehow need to Mirandize employees of a company and tell them, don't talk to me, because I don't represent them. There are ethical holes that you can fall into, though, if you're just taking advantage of unrepresented parties. So I'm not callous about it, but you're learning a lot of information that may not be helpful sometimes to the people you're talking to. Even if it's short of criminal, they may lose their jobs. Mm-hmm. In the worst circumstances, there are a lot of negative consequences for the people who are deeply involved in the investigation. Sometimes the CEO, sometimes the in-house lawyers are in the middle of these sorts of things. So it's ethically lots of traps. We could talk an hour just on that. And the problem is that when in a typical lawsuit, it gets filed, the complaint comes in, you get more time, you meet with the client 2 or 3 weeks later. In the crisis response, that's all happening in 24 hours.
What do you think? This actually make me think about something like with the securities, regulatory situation. If multiple people are named, generally the company pays for legal counsel for all those people. But interestingly, sort of each of their settlements sort of has to do with the overall settlement and how it all comes together. Yet each of them has their own personal need to be represented, and is like the company has to pay for their counsel, and there could be some challenges there. I think you're raising a really important point.
But in court, it works lots of different ways, and often the company will pay for counsel, and at some point the lawyers will say, we really need separate counsel for this person, and or you're going to have a conflict on this issue. Civil cases are an example of that as well. And sometimes the best thing for the company to do is to fire, in the financial services in particular, fire them.
Yeah.
And that's very good for the brand. It may or may not be good for the legal strategy, but you need to be balancing all those different things.
Right.
Terminations tend to create a conflict.
Yeah.
Jody, do you have any strategies for dealing with the sometimes hostile media?
Yeah, and I think this is one of the things that we generally go through when we talk about when we do media training with people is, you do not have to answer every question a reporter asks you, and there's a tendency to feel like you have to. And I think having a core messaging triangle and sticking to it is often the best way to go. And I'm going to use sort of a non-crisis situation. There was an analyst that we did media training for who was talking about luxury goods after the financial crisis. And at that time, every Coach, Nordstrom, the stocks were 75% of their pre-crisis level or more. And she had buy ratings on all of these. And she goes on CNBC and was interviewed by this gentleman who was completely hostile to any Wall Street analyst generally, but particularly hostile to her. And he went after her again and again, telling me, you have no sell ratings? None of your companies have sell ratings? It's all buy ratings? She was just cool under pressure. She had a clear message. She kept coming back to her message again and again. Those are your words, not mine. What we believe. She kept coming back again and again. It's sort of sticking to the fact that you've got a job to do to deliver your message, staying cool under pressure, realizing that that's your job, and giving it back to the reporter and saying, I don't agree with the premise of your question. What we're dealing with here is, and then rephrase the question the way you want to say it. So really going through it and being committed to the message and not feeling as if you have to answer every question that the reporter does. I also think that it's super helpful if somebody gets you on the phone out of the blue in the midst of a crisis, you happen to pick up your phone and a reporter's there, you don't have to take that call at that minute. And you can say, listen, I can answer your questions, but you need to send me an email with your questions, and I need to prepare for this. So here's my email address. Email it to me, and then you respond via email. You don't need to take that.
I'm sorry, I need to rush for a meeting, but what is it? I'll call you back. What is it that you want to talk to me about?
Right, exactly. That's another way to do it. Yeah.
Media training helps you immensely. You ask, I want to be cooperative. What is your deadline? So if you find out they have till 7 o'clock, you now know the subject. You can go talk to Jody. You can figure out their legal implications. You've got your media preparation cheat sheet. You've got your bullet points. Now you call them back. It's a completely different conversation than if you're just a nice person, pick up the phone and you're halfway through the conversation and you think, oh boy, this was a bad idea.
And then it goes down a path you don't want to go. And they may tell you, I've got 3 points I need to talk about. You can either get them to email me or you know what they are. But you can get back to them then after the fact and say, listen, I can answer 2 of the 3 questions. I'm not going to be able to talk about the 3rd one, but of the first one, this is what I can say. This is the 2nd one. This is what I can say. So again, it's sort of not agreeing that you have to answer every question that's asked of you.
Right. And what about after the PR crisis is over? What do you do then?
Dan probably has some thoughts on this too. I think, you want to go back through and evaluate really carefully what worked and what didn't work. You want to, could negative outcomes be avoided? If so, how? Again, you're hoping you're never going to have to go through these situations again, but it's always a good idea to do a post-mortem on any kind of a crisis situation. But one of the mistakes I think a lot of people do when they've been named in something negative, they face negative news, is they start to hide. They don't go to the charity function they were supposed to show up at. They don't take calls. They stop doing, media interviews on other topics because they're afraid that they're going to get asked about this topic. So, we think it's really important for people to stay visible, to get back out in the community as quickly as you can if you've been named in some sort of a negative situation. If you are asked to do an interview and you're worried that a reporter is going to ask a question about the negative matter, have a prepared statement to say, listen, I'm here to talk about that. I'm not prepared to talk about that topic. And if that's what the nature of this conversation is today, then we'll have to schedule a different conversation at another time. And control it. But I think you need to get back out there again. The other big issue that companies face is that negative news becomes the first thing that people see on their search. And so SEO continues to be a significant post-crisis issue for most companies, especially if it's a regulatory matter. The SEC matter it's a really well-traveled site. So if your name is on the SEC, it's going to be the first thing in search.
SEO is search engine optimization.
Exactly.
How does that work, and how can you help?
I am not going to make any promises, and a lot of people will sell you snake oil saying that we can get that off of your search. It doesn't work that quickly, but there are ways that you can slowly but surely push that news down, and it just takes some time. And it involves trying to get content that you've created placed on other well-traveled websites. It's getting other information out there legitimately that people would be searching for related to your name. And that could be on your own website. It can be on other websites with them pointing to you. And again, the algorithm for search changes all the time. I am not a search expert, but I do know, and we've worked with a lot of clients that have had, negative news. Our goal is often to push it down below the page so that it goes to the next page. You want to get to number 6 or number 7 with the news. And to do that, it just requires getting out and getting your name into the media or onto key websites so that starts to push down the other search. And time also helps. So again, it'll take time. You can spend a lot of money to try to do this, and some of it can be successful, but I think there's organic ways that you can do this to have a positive impact on where you're going to show up.
Right, and that's particularly true in the securities context. What we've had recently is plaintiffs' firms will announce whenever there's a regulatory announcement. Plaintiffs' firms will piggyback on that announcement and announce that they are conducting an independent investigation of whatever the subject matter of the regulatory announcement is. Mm-hmm. So now not only do you have the SEC, FINRA, state securities regulators in a Google search saying we've reached this sort of resolution with target X, you have 5 plaintiffs' firms on typically page 1 of Google saying they're conducting an investigation of target X. So that's particularly problematic and very good advice.
And obviously looking and trolling for plaintiffs, and plaintiffs' firms are getting more aggressive at creating their own media attacks on companies outside the courtroom. And there are instances where people have had targeted ads aimed at potential jurors, both on the plaintiff and the defense side. So you need to be conscious what's happening inside and outside the courtroom. Judges especially don't like that.
And we recently had an instance where one of our clients was the target of a regulatory settlement. And we found out after the fact that not only was the plaintiff's firm announcing its own investigation of the target, it was actually creating fake news articles to increase the hype as to get plaintiffs to go after this target. So they are ruthless.
Yeah. Totally ruthless, yeah.
And to the extent you can share, I realize a lot of this is confidential, but can you both give a couple examples of high publicity, high profile matters you've helped resolve?
No. Jody, you could go next. So, no, I can't. But there are lots of examples of it's all very specific and circumstantial, and I'm very impressed with the quality of the people I've worked with in dealing with difficult circumstances and acting very quickly. Doing the right thing is important. And I've had a number of instances where companies went out of their way to be generous to people who were hurt, including their own employees, that months later, when those people were important witnesses or even had the ability to sue the company, in one case they didn't. So you just can't underestimate that. And just one other kind of related point to your looking back after the fact analysis. Again, in the crisis response system, what you're often doing, again, business issues, is you're doing a root cause analysis. What happened? What went wrong here? How do we change it? Because you're often in the marketplace, you need to go forward and do things differently. And you also, in the internal investigation context, will be trying to find out, okay, just what happened? Who is to blame, if anybody? What did the company do wrong? What's the potential legal exposure? In both those circumstances, while you're doing it in real time, you need to understand that you're going to be wildly second-guessed later by people in whose financial interest it is to question the legitimacy of what you did, either as an independent internal investigation or as a root cause analysis. And that will happen in court and publicly and outside. And it's just, you need to understand, and I tell people from day one, you are creating evidence. You need to understand you're creating evidence. And it's again why attorney-client privilege and work product can be so important to try and limit what it is that you're creating and who's going to see it later.
That's a really good point.
And Jody?
I'm going to talk about two situations. One that John's familiar with. It was a SEC settlement for a company that had an absolutely pristine record with nothing on the record for any kind of regulatory matter. And, you know, again, they did exactly what you're talking about. They did an internal investigation as soon as they were aware they were facing this. They made all the right changes and they did everything right. But in this instance, there was really an earnest CEO who felt compelled to say something publicly because he felt terrible about this and wanted people to know that this will never happen again. And what we did is we crafted a core messaging triangle, and we thought really carefully about how we were going to communicate about it to each constituency. The CEO spent some time talking directly with some of their key clients. We prepared a statement for the media that was very short, very limited, one sentence. We got placement when the news first came out. I think it showed up in a legal publication, but somehow the word got to a local reporter, and we received his questions via email. And then they did not have a general counsel, but they had a staffer who was able to answer it via email, and the story went away in one day. We feel like that's a success. These are the kind of things now they're dealing with, trying to push that news down. It's still on their website, and that's going to be an ongoing thing for a little while. But for many people, you know, in today's news environment, these kinds of things can be a one-day news story if you handle it well. If you don't handle it well, it can get drawn out. So the goal often is to get it done, put it behind you, and it can usually be done pretty quickly. I'm going to talk about another situation that I personally went through with a company that I work with that you know, was a situation of fraud. We had one of the largest money market mutual funds, and this is many, many years ago. Since, you know, I think the financial crisis, there were a couple of money market funds that, quote unquote, broke the buck, meaning they went less than $1 per share, which may not mean a lot to all of you, but it was a really big deal at the time, and no money market fund had ever broken the buck. We had a situation where the largest single security in our money market fund had a fraud situation, and the CFO, you know, leaves the country. And the security was called Mercury Finance. It's sort of, some of you may remember this, but in a very short period of time, it was clear that our money market fund was going to break the buck because this security was going to default. So while the finance people were looking to get a bunch of people together to bail that security out of the fund and avoid the fund breaking the buck, the rest of us were sort of dealing with the communication strategy. We ended up creating a letter that we were able to send to shareholders because it was obviously a very public situation that laid out the specifics. The message in that letter was, this is a case of fraud. We did everything that was right. We bought the security out of it. The fund did not break the buck. You know, all is good. And that letter became the basis of the communication that we were able to give to the Wall Street Journal and other publications that controlled what we said. And as much as you can, you want to try to control the message in a situation like this and not put yourself in a situation where you're facing a lot of different questions. And it worked beautifully. We were able to get back to all the reporters. We emailed them a copy of the letter that they repeated again and again our messaging, and that became the quote from our company in the story. And the story went away very quickly. We were, transparent and proactive. We controlled the message, and ultimately the situation ended up, dying.
Just one final point from my perspective, which relates to message and channel. I was working with a high-profile PR person once, and he was putting together the statement, and I asked him, just how hefty is your defamation insurance? Because if you send that out, you're going to get sued. And he decided not to do it. When you are in litigation, you can say things in court, still in good faith, and you can get in trouble with the judge, but it comes with a privilege. So it's not unusual not to talk to the press at all, but have your pleading be written in a way that it's maybe more fulsome than it normally would be, but it communicates your message. And then the media can be pointed to your pleading, which is a public document. In terms of how some judges react, some judges think that if the lawyer takes that complaint, which is publicly filed, and sends it to the media, that is outside the court, not subject to the litigation privilege. It's really very difficult to predict how any particular judge is going to react to something. But at a minimum, if you have just publicly filed it, the lawyer can, or whomever can tell the press, here's where you can look for it. That's a really good way to tell your story, and it's defamation proof, and it's been vetted.
And how do you feel about that? I think a lot of times in a delicate situation like that, if you can point to a document that has your message in it and get a lawyer to pull from that can you've controlled that message then,
Oh, I think it's a wonderful idea, and I think that you can't just win the case in the courtroom. Putting the brand aside, if it's a high profile matter, you want to frame what the issues are. You want to be the first one to say what is going on, so that when people come into court, to the extent they saw it on social media, television, the news, or otherwise, they have some sense of what you think happened.
Yeah, right.
Well, thank you, Jody and Dan. We're running a little bit over our time, but to the extent anyone has questions, feel free to pose them to either our panelists. Well done. Well, thank you, everybody, for coming.
And I'll just add, John, that this cheat sheet is meant to be something that you can just look at, and it should be self-explanatory in terms of what I was trying to do. You also don't need a lot of resources. You don't need an outside lawyer to help you think about these things. Your company should think about it internally, who it is that you're going to call and how you're going to react, and who's going to be responsible for what. And for that matter, we're also happy to meet with you separately and take you through the exercise. But thank you very much.
Yeah, thanks. Good to be here.